5 seconds. Start. Judgment. It is therefore decided to take evidence of the plaintiffs in the instant proceedings, although ex parte proceedings of the case. In order to prove their case, the plaintiff number 3 himself and 2 witnesses were examined as PW1, 2, 3 and produced 3 documents marked at exhibits P1 and P3. But none appeared and responded the case even to cross-examined PW1, 2, 3. Thus proceed ahead without cross-examination of PW1, 2, 3. Learned counsel for plaintiffs has submitted that he has no further evidence to lead. As such, further evidence of plaintiffs was taken as closed. Heard the arguments canvassed by the learned counsel for the plaintiffs and perused the written argument filed by the plaintiff and materials placed before the court. Again, by taking reliance in Ramesh versus Anil, decided on 5th May 2003, reported in AIR 2003 SC 2508, wherein their Lordship of Honorable Supreme Court has held that even if the suit proceeds ex parte and in the absence of written statement, unless the applicability of Order 10 Rule 11 of the CPC is attracted and the court acts thereunder, the necessity of proof by the plaintiff of his case to the satisfaction of the court cannot be dispensed with. In the absence of denial of plaint averments, the burden of proof on the plaintiff is not very heavy. A prima facie proof of the relevant facts constituting the cause of action would suffice, and the court would grant the plaintiff such relief as to which he may in law be found entitled. In a case which has proceeded ex parte, the court is not bound to frame issues Order 10 and deliver the judgment on every issue as required by Order 11 Rule 5. At the trial court would scrutinize the available pleadings and documents, consider the evidence adduced, and would do well to frame the point for determination and proceed to construct the ex parte judgment dealing with the points at issue one by one. Merely because the defendant is absent, the court shall not admit evidence the admissibility whereof is excluded by law, nor permit its decision being influenced by irrelevant or inadmissible evidence. Thus, on perusal of pleadings, entire records, and on hearing of learned counsel for the plaintiff, following points should determine the case, namely: the points that would arise for consideration of this court are as under. 1. Whether the plaintiffs prove that they have been in actual physical possession and enjoyment of suit property as on the date of suit. Whether the plaintiffs prove the interference by the defendant. Whether the plaintiffs prove that they are entitled for the reliefs sought for what order or decree.